Today's guest is an attorney from New York City that we haven't been on together for 2 years. And he was awesome last time, and I'm really excited to have him back on today. So it is Jeff Kaplan. Let's see if he's here yet. Not yet. But anyway, we were coming up with ideas of what to talk about because last time the topic was on how to handle or how to move a. But today, and Jeff, I see you. I let you in. Okay, you did it. It worked.
Told you I could figure it out.
All right. I was just saying our last interview was excellent, where you were talking about how to push a case forward. And so today I wanted to talk about how to make sure that we, not just us, but that we send clients to you or people understand how to be what we call the teacher's pet of clients for their attorney. Because I think there's a lot of misconceptions out there. So before you introduce yourself, how important is it for an attorney to have a good relationship with a client?
Well, for a good lawyer, it's the most important thing.
Mm-hmm.
And the attorney-client relationship is so sacred. But I find that there are, and thank God it's the exception, not the rule, there are a number of attorneys out there who don't always treat their clients as if, that relationship is so important. And it's just not something you like to see at all. And I think it really contributes to a breakdown, obviously, in the relationship, but also in the representation. So it's probably a double whammy of just really bad mojo that you don't want any part of. You got to have a great relationship. You got to be a team member with your attorney. You got to be on the same page, and you got to have an experienced attorney who knows what they're doing at all times and can give you the kind of really the good advice that you need, because certainly there's enough bad advice going around out there.
Yeah, tell me about it. Yeah. So Jeff, can you introduce yourself and say
Sure.
exactly who you are and where you
Sure.
practice?
Sure. I'm a New York City divorce attorney. My office is here in Midtown. I've been practicing matrimonial and family law for about 29 years, and my practice is exclusive. Well, I don't want to say exclusively, but it's more or less centered in the five boroughs of New York, as far north as Westchester County. I've occasionally been spotted in Dutchess, and I'll go out to Nassau County, and if you really beg me, maybe Suffolk.
Okay. All right. Well, so in terms of the relationship, to me, my relationship with my attorney was an intimate relationship because I felt like my attorney knew more than anybody else about my case, and he became expensively my best friend that year that it took to get the divorce. And so we don't want people to rely on their attorney for everything and spend tons of money, but I think it's important to address maybe some myths about what to expect from an attorney, because in our world of dealing with only high conflict divorces, separations, custody battles, and co-parenting situations, I think people assume that the attorney has more responsibility than they actually have. So can you clarify a few myths that you see or misconceptions about what people think and why it's not true?
Sure. Well, I'm glad to hear that your relationship with your attorney was what you described as, much more involved, and, you described it perfectly as intimate. Your lawyer really, and I say this to a lot of my clients, I know your life at least as well as you do, maybe better. And I say maybe better because I sort of know, because I've been through divorces so many hundreds and hundreds and hundreds of times, that I get a sense for where things are going to go. So whereas you know your life and you know your facts and you're going to talk to me and give me all that information, and I'm going to spend a lot of time pulling it out of you, I also have sort of a crystal ball, and I can most of the time, give you a fair estimation of where things are going to end up based upon that whole scenario. So yeah, super important that, your attorney know your case and your life and your facts and your finances and your custody situation, or whatever, the issues are that are involved in your matter, better than you do, or at least as well as you do. So nothing amazes me more than going to court, being in front of the court, and the court will ask a question like, what's the date of the marriage? Easy enough. And those are just simple little things that if you don't know that, you're really not prepared as a lawyer. So I never walk into court and don't have, sort of a cheat sheet where I've got all the kids' names, their dates of birth, any special circumstances that I need to know, bank account information, the address where the parties live, the date of their marriage, the date of their separation, the date of the commencement of the action. And that's just really the basic stuff. But it never really ceases to amaze me, where the judge will ask someone while they're arguing a motion or even on trial, well, what is this date or this significant date? And, I look over at my adversaries just scratching their head like, I don't know. I'll usually pipe up and, show off and blurt it out because I know what it is. But, it's little things like that.
Well,
Really,
as you're saying that, I'm thinking like of a client recently who was saying that she had an attorney who forgot her kids' names, forgot which was a boy and a girl, and was mispronouncing things. And she was horrified and so offended because she felt like she didn't even matter to her
yeah,
attorney. And
there's
how could like the most basic information not have been
right,
absorbed? And all of the money that she was paying and all the hours she had spent with this attorney for them not even to remember
right,
who and what her
right.
kids were.
So again, very, very distressing for a client to be in a situation like that. What is a client like that really going to think in terms of, gee, my lawyer doesn't even know the names of my children or their ages, or that perhaps one has some special needs, where they go to school, so on and so forth. What do they know about arguing my case, right? How do they know how to present my case if they don't even have this basic information? So again, as an attorney, I mean, to not have that information, and again, it is the exception, it's not the rule. Most attorneys are on the ball and they've got it. And I don't run into a lot of situations where they're not prepared, but when you do, you know it when you see it, and certainly take advantage of that type of situation to the extent you can. The court is already aware of it. They're cognizant of the fact that, well, somebody's really not prepared here. And, I think they do draw, it's a negative inference that the court really is able to, look at one party and say, you're just not prepared. Maybe your theory of the case, or your facts are, something I should really take a close look at, because maybe you're not so credible either. So it does
So
hurt. It does hurt
how
the
can
client.
a client make sure that their lawyer has that pertinent information without being annoying?
Sure. Well, it really starts before you hire a lawyer. It starts in that sort of vetting process where you're getting recommendations from colleagues, friends, people who have been through the process before. What can you tell me about this lawyer or that lawyer? Were they prepared? Did they listen to you? Did they give you advice? Did they answer your questions? Did they take the time to really get to know you? And if you've really gone through the process of hiring a lawyer the way you should, then you're going to know right away that this is someone that I can be that intimate, lawyer-client partnership with. And this is something that's really going to benefit me as I go through what arguably is a very unpleasant part of one's life when they do face a high conflict divorce. So do your homework. Get recommendations, from friends and colleagues who, again, really know, do you really know this lawyer that you're saying is like, he's awesome, he's great? Well, did you read about that on the internet? Or, was he your lawyer, or was he your friend's lawyer? And are they coming from a place of recommending from, personal knowledge and information? I think that's really, really
Yeah.
important.
Yeah. And we always stress that your attorney is supposed to be your ally and your advocate, but often people feel like, I don't trust my attorney anymore. I don't know.
Right.
Do you see that sometimes with clients where they're just like, I'm a little worried?
You do run into it occasionally. You do see it. It kind of develops into two sort of camps. You do find some clients who take the position that I don't really trust my attorney, not because they're not prepared or not doing their job, but because I don't like what I'm hearing. So there have been situations where I've run into clients that don't really want to read the writing that's on the wall. Lawyers tend to be they're like human beings in some ways, but they have egos, and there are some lawyers who just are afraid to be really brutally honest with their clients about certain things, and that's a real disservice to anyone.
Yeah.
Whether you're a lawyer or a doctor or whatever your service you're providing, you have to be honest and open with your clients. So when you're putting your cases together and you're getting your facts together because you're going to court or you're doing a hearing or even arguing a motion, if things really aren't supporting your client's position, and the law doesn't support it, or the facts don't support it, or the double whammy of law and facts are both against you, you still can go in there and do a bang up job, and you do that for your client. But manage expectations and have those discussions with your client about the likelihood of prevailing on this issue or this motion is probably lower or non-existent for whatever reason. So your client is from the very start of the relationship really in the know. I mean, a lawyer is someone who's answering questions, giving an opinion, and that's not always, good news in all respects. And you have to be able to tell your client sometimes bad news, and that's hard for lawyers sometimes to do.
Yeah.
They want to, tell their clients like, I'm going to win this for you. This is great. I'm going to get custody of those kids and so on and so forth. And at the end of the day, for someone who tries cases like myself, you really have to be careful, because you have to tell your client, it looks like, we're going to prevail, but at the end of the day, we have a capable adversary, and, the facts aren't all in your favor. And there's a judge who's going to be ultimately deciding the situation and getting recommendations from who knows who else, attorneys for the children, forensic professionals. So there's a lot of different moving parts, and you really need to manage expectations. And when you're a good team member with your client and you have that kind of intimate relationship, there are no surprises, or very few surprises. And when there are some surprises, you're able to deal with them, because you've sort of thought things through, like this could happen or that could happen, and we'll be ready for this and we'll be ready for that, because you've really gotten to know the case. And when you have to dance left or dance right very quickly, and things change very rapidly, especially in trials, and you have to really be on your feet and be able to do that kind of a dance,
Yeah,
especially in
I
trial.
mean, and so you and I are both New Yorkers, and so one thing that Chris and I do is we tell our clients just what you said, that we call it the harsh New York reality check.
Mm-hmm.
And so obviously we're not attorneys, but sometimes they'll come to us and be like, "This is what I want. I want sole custody because I've been the primary parent." Blah blah blah, and we're like, "Okay,
Yep.
well, based on what we've seen, I don't know about that, and we'd
Right.
rather that you hear it earlier rather than later, because there's also something called the cost benefit analysis. So not even just about whether you're going to prevail, but like how much is going to cost you to file this motion,
Right.
especially if you don't have a great chance of prevailing in court.
That's right.
And
That's
then there's
right.
enforcement. How long that takes.
Absolutely. Absolutely. And, you really have to evaluate those types of things, because it is so expensive to litigate. And, you may start out with a plan, and you have to be able to change that plan if things aren't going your way. If you've got a judge who you think is ruling against you, or is ruling against you, and the writing's on the wall. I've been involved in situations where the client still wants to, move forward, and things aren't going the way the client wants to go for whatever reason. The facts are against the client, or what have you. And, there are a lot of times where the client starts to take the position that what are you working against me? Actually, no, I'm actually being completely brutally honest with you about, the realities of the situation. And if I were just candy coating things and telling you what you want to hear, then I'd really be working against you. And that's not the kind of lawyer you want. That's really not, the type of lawyer-client relationship anybody would really want.
Yeah. And speaking of working for and against you, so I know that one thing people are worried about, especially in our community, is they'll say, my lawyer is friends with my ex's lawyer, and they're talking, and I'm sure they're just figuring out ways they could make more money off
Mm,
us. What
yeah.
do you think?
You hear that kind of thing every once in a while. And you know what? I'm on the inside too. I can't say that it hasn't happened. It's horrible to think that anyone would ever want to conspire with their friend who's the other lawyer to try to resolve things. The way I look at that situation, because even though the New York legal community is as big as it is, it's really not all that big. Most of us know each other very well. I've been doing this for 29 years. I've come across pretty much everyone, litigated against the best and the worst. And I certainly count a fair number of, lawyers amongst my friends and colleagues. And I tell my clients it's really a benefit to have a good relationship with the other lawyer. And again, in 29 years, I've never had a discussion with another lawyer, and never will, about, hey, let's run the file up and cost the clients extra money and make all this kind of money. I mean, not only is it unethical, but quite frankly, it's just an affront to the entire system, to a waste of judicial resources. For me, a relationship with the other lawyer, a good relationship, and I always look forward to finding, whoever my adversary is on a certain case is someone that I do know and I do trust, and is a very, very good lawyer, because I know the very good lawyers are like-minded in terms of how I approach a case. Like, oh, that's somebody we can work with. Chances are we're going to settle this case. and not have to go through all the litigation. And certainly there's not going to be any personal animosity between the lawyers, because that's a complete waste of money when the two lawyers, for whatever reason, they have egos, can't get past, the fact that they just want to beat each other in court. It just ends up costing the client money unnecessarily. And that is something that I just avoid at all costs. So when I have a friend or a colleague on the other side, that's a good thing. It's a good sign. It's an opportunity really to settle the case and make more progress. You're not going to be mired down and having little skirmishes about discovery and financial exchanges of information, because the other lawyer well, and you can just pick up the phone and hey Tom, can you send those documents over? I didn't get them. And that way you don't have to file a motion in most circumstances. Now of course you could have a problem with a client, well, and it also helps sometimes to have a relationship with the other lawyer who, maybe they can talk off the record and say, like, I'm having a problem with my client. Maybe you can write a letter to the court and we can push this along and get it done or something like that. So it really helps, in my opinion, to move things along better, to have a good relationship with the other lawyer.
Yeah. When a few years, Chris has a good friend from college who's a divorce attorney down in Virginia. And I remember before we put together our first book, we were interviewing her, and at the time we were thinking, okay, if our client is up against a really difficult ex, then it's guaranteed to be a very difficult time in court. And she said, absolutely not, because if you have two great professionals working together, you can completely avoid the whole legal abuse, like litigation craziness.
Yeah.
So one of the best things you can do is have a lawyer that gets along with opposing counsel. And I remember in my own divorce, my ex went through 3 attorneys, but unfortunately, the last couple were very difficult for my attorney, who was, I thought my attorney was lovely and he got along with everyone. And I remember, never forget the day he called and said, I have terrible news. Your ex just switched to like one of the 2 attorneys in the area that I cannot work with, and the chances of trial just increased by 80%.
Sure.
And I was like, oh,
yeah. That makes total sense. That you do see occasionally that happens. There are 1 or 2 around where when they're on the other side, I'm like, oh, gee, here we go. Like, you still do what you can to try to, take the off ramp for settlement if you're able to, and you do that very carefully, because your client has to be amenable to an agreement, and of course the other side has to be also. So if there's a way to do that, it's certainly the wonderful way to proceed. But you do run into a couple of people. It's infrequent, but you just like your experience, that the chances of trying to resolve the situation are probably a lot less now.
Yeah. So another thing that we see in our community is people saying, well, my ex, and this is my post this morning, my ex has chosen a lawyer just like them.
Mm-hmm.
And so it's really, really difficult.
Sure. Yeah, you see
how do you work with like really difficult opposing counsel when you're trying to settle? And for those of you that aren't aware, it's always better to settle outside of court if possible.
Sure.
But how do you deal with like an opponent who's similar to a very difficult person?
Sure. And you run into that type of person all the time. And they can be very good lawyers that just happen to be very difficult people to deal with. And they could be very much like their client who, has some issues. And one of them is, inability to reach an amicable resolution or an agreement about any issues whatsoever. So if you find yourself in that type of situation, one of the ways to approach it is, try to get before the court to let the court know that, this is really an unreasonable position. We're trying to, whatever the issue is, resolve this in a reasonable fashion. We've been reasonable. And it's one thing to give lip service to, like, I've been reasonable. First of all, you have to make sure you have been. So if you're approaching the situation in a reasonable fashion and you just have an extremely difficult individual on the other side, you really can make a lot of progress putting that in front of the court and saying that, this is really now reaching the level of not just an unreasonable position, but just an ultra like unreasonable position. It's not even really supported by the facts and the law, and it's now starting to become an obstruction to us trying to resolve this case. But for this issue, hey, we might have a settlement here. There's a hold up here because the other side is just so unreasonable and unwilling to take a reasonable approach to the situation, and you might be able to get the judge behind you on an issue like that. But that is a challenge. That is an aspect of this where you know, sometimes you give a little of it back and the other side realizes like, oh, okay, well, you know, I put an amount of, you know, force into being an unreasonable person and I'm going to get the same amount of force thrown right back in my face. And some people reach a point during their divorce where their litigation tolerance falls off, especially when they start to get bills like, oh, gee, it was $25,000 in legal fees this month, all
Mhm.
because, you know, my position was so unreasonable and I filed this motion, which, you know, I probably could have resolved more easily. So there are some individuals who will wake up, will sober up, so to speak, about that kind
Mhm.
of behavior. And you sometimes have to give it back to them. So, but that's a discussion you should have with your client about how unreasonable the other side is, and I'm sorry, and you know, here are our options. We do have a couple of different ways to approach this. So after, you know, a discussion with a client about what is the best option, hopefully, you know, you make some progress moving forward with option A, and if that doesn't work, you go to option B.
Yeah, as you're talking, I'm thinking this is perfect timing because one of the things that Chris and I do more than anything with everybody is something we call strategic communication, where we say that's not between the lawyers necessarily, but between the client and their ex, where we say you want to appear to be the best co-parent possible, you want to appear as reasonable as possible. And even though you are communicating with your ex, you are really writing for that invisible audience of who's
Yes.
watching in the background. If it gets to court, a custody evaluator, an attorney for the child, et cetera. And so, but one thing we encourage them to do, which I think is also helpful for their attorneys, is to try to communicate in writing so it's documented
Mm-hmm.
as much as possible in terms of trying to work it out outside of court, to focus on supporting the other parent's relationship with the child unless there's been documented abuse, to
Right.
understand what undermining a relationship looks like and make sure that you're not the one doing it, but to keep saying, I'm trying, so that if the lawyer does have to go to a judge or to opposing counsel and say, look at all of the chances, look at all the opportunities we had to resolve this. And you can see that my client was the one who kept asking and asking and asking, trying to negotiate and try to mediate. And we don't
Mm-hmm.
understand why the other side wouldn't want the same thing, which in my mind is thinking that's what the court wants. The court is always saying, figure it out yourselves, right?
Mm-hmm.
Because there's no time and
Right.
the resources. So they always would prefer for you to try to do what you can. So by establishing the patterns of behavior and having like emails that are very well organized, we
Mm-hmm.
call that targeted
Yep.
documentation. They
Yep.
can give it to their attorney and it will hopefully make your job easier because you'd be like, ooh, you've been this wonderful client.
Yeah.
You're gonna look good, hopefully,
Yep.
and I can use this. And it's not just like binders of paper of these angry emails and OFW
Yes.
4,000 page threads that I'm gonna have to sift through, and then you're gonna get mad at me for charging you thousands of dollars of my time to have my paralegals look at it, right?
Sure. You bring up an excellent point, and it really relates to the topic you had asked me to comment on. You know, how do you become the class pet of clients? And I'm always reminded of a comment from Tim Tippins, who gives this big, you know, matrimonial lecture to all the divorce lawyers. And he said that, you know, the two most important tools in the lawyer's toolbox are the duct tape and the hammer. And the duct tape is, you know, cover the client's mouth, and the hammer is to smash the keyboards and the iPhones so that they can't type. And you know, he's absolutely right. I talk to my clients right from the very start. Cut out with using the social media. It is such a, you know, a fertile ground for discovery for your adversary. You know, to see that you're taking pictures of yourself out drunk in bars, and you know, you want to show up in court and argue you don't have a drinking problem. Well, you might not, but certainly doesn't, you know, help that every weekend, you know, you're staggering around in these videos that are posted on Instagram or Facebook or what have you. And so we start with that kind of thing, but we move immediately to emails, texts, you know, our family wizards, things of that nature. You have to kill them with kindness.
Right.
You really, really are not doing yourself a favor. And I know these are very emotional situations. I get it. And I know you want to respond with, you know, the same sort of energy and lightning force that your spouse has, you know, accused you of doing this to the kids or that to the kids, but it doesn't help anyone. It really doesn't. It certainly doesn't help your case. As lawyers who try cases, we use these exhibits, if you will, to demonstrate our certain, positions or levels of unreasonableness to the court at trial. And, our family wizard comes to mind, and we'll download these exhibits, 4,000, 6,000 pages of our family wizard messages between clients. And, it's just terrible and it's awful. And, I tell my clients, like, if you're going to write an email or a text, even if you're emotional and upset, first of all, don't write it while you're emotional and upset. Some things you have to respond to, but kill them with kindness. Nothing upsets a spouse more than when they've been nasty and angry and your response is, well, I really don't agree with you about that. And I would hope that we'd find a way to resolve this situation and move forward for the best, of our interests of our children, or what have you, whatever the issue is. But, when a judge sees that, they're going to see somebody just acting completely like in an unhinged fashion, maybe even borderline harassment or threatening. And, those are things which, the court is going to weigh, heavily when it makes certain determinations. And the response from my client would hopefully have been much more measured. And, I really want to try to find a way to resolve this. And, I don't agree with your position. I understand, this, that, or the other. So, kill them with kindness. Those are the types of things that are really going to help you out in the long run, rather than, just turning around and like, go to hell and you're a piece of this, that, or the other. And,
Right.
we see it all day long. And, it's just, that leads to orders of protection and, then violations of orders of protection and, contempt applications because so-and-so sent me a text and it wasn't related to the kids. And it's just mind numbing, what people are capable of doing to one another and, in the name of the law.
Yeah, I know. And so with the strategic communication, I don't know if I told you, but Chris and I are putting out this big online education program called From Fear to Fierce in Family Court. And the first course is on strategic communication. It's called How to Communicate with Your Ex Without Destroying Your Case or Losing Your Mind.
Yeah.
Because it is the hardest thing for people to, we have like a dog with a muzzle on that we always to be like, you have to stop, wait. We put them on what's called the permission slip plan, because my background is as a teacher. We'll be like, before you send it to us. We will proofread and edit it for you so you have clean hands.
Right.
Because we are always conscious of that invisible audience. So we say we need to use court-approved language. And we don't even say things like in the best interest of our child, because to me, it sounds like, oh, you're just pandering to that invisible audience.
Yep.
But to pick something very specific, like, talk about your child's stable routine being disrupted. That's one of the things that the court cares about, but not just like in the best interest, and to try not to sound too authoritative and all that other stuff. But but I'm thrilled to hear you talk about how important it is to communicate properly, because people don't realize it and they just pop off, and then they were like, oops, oh well. And then lawyers are saying, I have to babysit my client. That's not my job.
That's right. That's right. And you're showing up for the court appearance, and the other side has the pile of papers ready to go. Like, judge, you have to see the awful things that have been said about my client. This is just unreasonable, and this really, this constitutes a family offense. This is this proves the point that this parent is probably not the best suited for to be the custodial parent for whatever reason. And those are the types of exhibits that will undeniably be used against you.
Right. Oh, so glad that you're saying that. All right. So flipping down to helpful things. So this is what you should not be doing, but what should people be doing to be that teacher's pet for their attorney? Like, what can people do better and hopefully save them time, money, and energy in the process?
One of the biggest things is every divorce case starts out with the preparation of a statement of net worth, which is very simply just a document, setting forth your monthly expenses, your income, your assets. And New York State is a compulsory financial disclosure state. Everybody is going to see everything. There's really nothing that's off limits. They try to limit it to a certain number of years that really are relevant. They go back 36 months or 48 months or sometimes 60 months. But the bottom line is you have to be transparent about that sort of thing. And I'm always amazed that there are some clients who are like, I'm not going to give my American Express statements. That's my personal business. I can't. And well, it doesn't really work that way. You have to give your American Express statements or your Visa statements or whatever they're asking for, and you're going to get your spouse's statements. And I am always amazed that, clients are a little reluctant because they just feel that that's such a personal violation. So one of the things we talk about early on with our clients is that there really has to be that transparency, and you can't hold back because that's going to delay the whole process, and it might even lead to motion practice, and those are not the kinds of delays you want and the expenses you want to incur. So you really have to be upfront, and if there are some things in those statements that are embarrassing, well, let's talk about them. Be upfront with your lawyer, be honest, whatever they are. Believe me, I've seen it all, had to deal with it all. So there's nothing that you really can't get past, and if it's really, really egregious, and there's a marital waste claim or something, well, even that can be dealt with. So it's better to, just to be forthright with it because, well, first of all, you have to be. And second of all, it's just going to delay and frustrate and cost you money in the end. So when your lawyer's asking you to, like, give the statements and things of that nature, be the client who, produces it all. I'm always amazed by clients who tell me, like, oh, it's so much work to download my American Express statements. And really, okay. I think it takes about 30 seconds to do it, even with a basic level of understanding of computers. So you can download your statements and email PDFs over to your lawyers and things of that nature, and your tax returns, put all that stuff together, and take a crack at filling out that statement of net worth. I'm always amazed when I send out the statement of net worth and I tell my clients, listen, some of this stuff is not going to jump right out at you. Don't worry about it, but do the best job that you can, and give me the rough draft back, and my office will put it together, and so on and so forth. And I'll get these things back, and the whole section on, like, what your monthly mortgage is just blank. I'm like, okay, well, can you send me your mortgage statement? I'll figure it out from there. Like, oh God, I got to download that. Like, yeah. So
Yeah, so I want to ask you a question about that because this comes up all the time. So let's say I'm giving you everything and the other side is not producing anything. And then I feel, well, why am I the one who has to do everything? Why don't we just not do it until they do it?
right. That's an excellent point and terrible advice to give a client. So I always tell my clients, oh, you want to be the bad actor in this case. So I'd rather you be the judge's pet,
Right.
the person who, gave all the information over and didn't, hold back anything. And then I'll handle the aspect of, notifying the court that somebody's not complying with discovery. And there are a whole bunch of, remedies, if necessary, that you can use to, persuade or force the other side to comply. Everything from, moving to strike an answer, something like that, to, a motion for counsel fees, because, you've had to bring a motion to compel the disclosure of certain information that you must have for this case. So, you have to make a good faith attempt to resolve those things with the other lawyer. So your lawyer will make sure they've done that in written letters. And then, after a letter or two, I'm sorry, I have to, seek the court's intervention. I'm bringing a motion and I'm going to ask for counsel fees because you shouldn't have to pay,
Mhm.
for your recalcitrant spouse's, inability to, follow even the basic rules of, matrimonial disclosure. So make sure your lawyer, brings that fee application. And if it costs $7,500 for that motion, you should have your counsel fees paid. And in most instances where it's really egregious conduct, most judges are pretty good about awarding that kind of thing. There's just no excuse. They'll try to really resolve it beforehand. But if they have to actually decide that kind of motion, there's a fair chance that you're going to get your fees paid for. And
Yeah,
that's a,
yeah, that's great. All right.
that's a thing.
I see I see a question. What's the best way to prepare text conversations for you as an attorney to read and review?
Right. So again, it goes back to sort of knowing your client intimately. Right away, when the relationship with a client is starting, you're looking at certain texts and emails and things of that nature. If you have to proofread your client's texts, emails, things of that nature, hopefully your client's going to learn sort of what the style is, but you really should go through the basics right at the very beginning with your client about the do's and don'ts, and killing them with kindness, and make sure your client understands that, if you're going to write these types of messages, this is how you write them. if you want me to review, every message before you write it, that's fine. But, it's $600 an hour. As long as you don't mind.
We can do that cheaper than you.
Right,
Sorry to take
right.
away a little of that business, Jeff.
Right, right. So there's a point where, it's not rocket science, it's common sense. And I find that if a client is really struggling with that, then it's probably a problem we have to address with the client rather than, me writing all of the emails and texts. There have been circumstances where I have written them, but it tends to sort of be the exception, not the rule. And I try to get the client really to be able to communicate themselves. And I find that most clients they can do it on their own.
Yeah, yeah. We find they need a lot of help, but ours are the extreme cases.
Well, yeah.
Because but people have to learn, because the divorce and the litigation and the legal stuff is going to go away, and you've still got the rest of that kid's life that you're trying to co-parent with the other person.
Right.
No one's going to be able to step in and be a buffer. And to me, AI that's a tool, but that's not going to take over your ability to communicate.
Right. People have to learn to co-parent, because when the smoke clears and the divorce is over, there's no judge, the lawyers are gone, and you really have to be able to co-parent. You really have to be able to communicate, in some form or fashion. And I've certainly been involved in enough, very high conflict situations where there will never be any communication, despite everyone's best efforts.
Mm-hmm.
But you hope that those are the cases that are really few and far between, not the rule. But you do see a fair number of those types of unfortunate situations.
Yeah. All right. So what other things can people do to be your favorite client?
So I guess another really, really big one for me is be very, very open and honest with your lawyer, from day one. When you're having those discussions with your attorney about, where have you been, where are you, and where are you going, it's really a, sort of a factual, chronological breakdown of, how you got to this situation and what's going on, what led you to, this conflict. So, be very candid with your lawyer in terms of the facts. And, I do find that there are some situations where there's an embellishment or unfortunately just an outright sort of misrepresentation regarding some of the facts. That's not going to help anybody. And telling your lawyer something that's just not truthful is likely going to come back to haunt you at some point in the litigation, because you don't know what evidence is lurking around out there that's completely contradictory. Mm-hmm. And it's almost tantamount to going to the doctor's office, and you're not feeling well, you have symptoms, you just decide, well, I don't need to tell him that, I don't want to be honest with him. I feel great, doc, everything's great. Well, how do you diagnose and deal with a problem if you really don't know what the underlying issues are? So mm-hmm. That, and I understand when you're meeting someone, a lawyer, really for the first time, there's not always a genuine openness, but a good lawyer hopefully will be able to develop a relationship with their client, which is brutally honest, and that works both ways too. The lawyer has to be very honest with the client in terms of managing expectations, and certainly being candid about the state of the law and those types of issues. But really, the client has to be very candid and very open and very, very accurate with the true state of the facts and what's really going on. You do tend to unfortunately see situations where the client is just not, in all cases, honest with you about certain things, and that's just not helping the client's situation at all.
Yeah, I mean, for something to come out in court where your lawyer isn't aware, that's embarrassing and awful.
Yeah.
How are you
all the time
supposed to deal with it as an attorney when it's like the other side comes up with something, you're like,
yeah. You deal with it best by being super, super prepared. So you can narrow down the time frame you're talking about, and if you have some doubts or some questions for the client, I always prepare my clients brutally before a hearing or trial. We'll sit across the desk from each other, and I'll cross-examine my own client about this, that, and the other. So if I have any questions, or I don't want to use the word doubts, that's a little harsh, but if I have any gray areas that I'd like clarification about, I'll really focus on those types of tough issues, because I know my adversary, most likely, if they've done their job, is going to come right for those types of issues. And I want my client to be prepared. And if my client can't answer those types of things, and I'll confront my client with exhibits and messages that they've written, and just ask them to explain. So hopefully we've gone through those things and prepared the situation such that you're not caught being untruthful during a cross examination, because these are credibility determinations by judges in most instances, and without your credibility, you're in big trouble.
Yeah, and I'm so glad that you mentioned that you do that, because I don't think a lot of lawyers prepare their clients for a trial.
Yeah.
Like, we often get people who say, I say, what's the strategy, or what's coming up? They're like, I don't even know. Well, I know we have a trial. I'm not really sure what it is.
Nope.
My lawyer hasn't told me anything, and I am terrified. And
Yeah.
so it's a matter of guessing what opposing counsel might ask. But
Yeah.
I don't, I'm not their attorney, so I have no idea
Yeah.
of all the details. So
There's
that's great that you
no
do that.
Yeah, there's
'Cause
no better way to not prepare adequately than to really not sit just really face to face with your client. You can do it virtually, and I try to do it in person though, and really grill your client about certain aspects of the case and ask them really tough questions, which for the lawyers don't seem all that tough, but when you're confronted with a question while you're on the witness stand, it's a completely different situation for a layperson who doesn't do a lot of hearings, and it's nerve-wracking, and the judges here and the court officers and the stenographers and the other lawyers, the one asking the questions, maybe you don't like that person. So clients are a little nervous, and they have to be prepared to answer the tough questions. And it can be something as simple as, so what are you asking the court to do here? What are you asking this court to award you in terms of access with your children? And I always like to ask questions like that of my adversary, because I catch them off guard all the time. Like, Mr. Kaplan, what do you mean? What am I asking the court to do? I'm not prepared for that question. Like, really? Well, you understand this is a custody trial. We're here, to talk
Like,
about
why are we here?
custody. You're asking this court in some form or fashion to award you some access, right? Can you tell me what the access is that you're asking this court? Oh my God, can I have a recess, please? No, not right now. Can't do that.
Wow.
So, it seems so basic. Like, how could you not have prepared your client for that sort of thing? But believe it or not, it does happen. Clients just aren't really ready for those types of questions. I like to share my outlines with my clients, and I tell them, I've written these questions out, but it's really, for me, it's not so much. I don't really follow the outlines because I know your case. It's in my mind, and I get rolling, and I just start to ask a lot of questions. But in the end of the day, I do use it as sort of a checklist. Make sure I've covered all these different areas. We don't want to, not ask a question that we thought was relevant or important for our case, that sort of thing. So.
Yeah. All right. Can you give us a couple more strong questions you think are asked during trial? And imagine that it's a custody battle, because that's what we deal with more than anything.
Sure. Sure. Well, obviously it's extremely fact specific, but when I'm cross-examining my adversary, I really delight in using exhibits, and I like to use those bad exhibits that we talked about.
Uh-huh.
So for instance, if the issue is, the parent is not willing to foster a relationship with the non-custodial parent for whatever reason. I've had situations where, for whatever reason, and we're assuming they're both decent parents, that no one's really abusive or neglectful. I've had situations where, for whatever reason, and I'll just use mom as the bad actor in this case, it's just an example, but there have been situations where mom is just unwilling to give dad 5 extra minutes of time. Dad contacts mom and says, "Hey, I'd like to take the kids to, some Christmas presentation this weekend. I know it's not my weekend. I don't have regular access during this period of time." And reasonable enough request. And mom's reaction is like, go pound salt, or there's some exhibit that she's responded to that is maybe nasty and maybe mean, because there's emotions that are running high. So I'll use that as a wonderful way to cross-examine the other parent about it. I'll confront them with it. Hey, do you see this? It's our family wizard. It's you sent it on this date, and he asked you what otherwise was a pretty reasonable request, and you didn't respond and say, "Oh no, we're going to be at Grandma Sue's that weekend. I'm sorry, we had made some plans." There was none of that there. So to me, that's a field day. I mean,
Mm-hmm.
wonderful. So you didn't tell him you had other plans or anything like that. You said absolutely not. Yeah, I won't give you an extra second with these kids. Blah blah blah. So, and you have a judge who's hearing this kind of thing saying, "Oh, one of the factors under the domestic relations law that I have to consider in a custody determination is whether or not the non-custodial parent, or whether the custodial parent is fostering the relationship with the non-custodial parent. Is there a likelihood that this is going to be a problem?" So those are the types of examples and sort of the line of questions that I would cross-examine on that really bring out that point that this is it's an unreasonable person. She's not giving like reasonable excuses, saying, "Well, not this weekend. How about next weekend?" Something like that.
Mm-hmm.
Nothing like that. Just no, absolutely not. Not willing to do it for you.
Oh, this is
So,
super helpful because this is right in our,
right,
you
right.
know,
But
with our clients.
and when you're really, really prepared and you've read those messages, you'll pick out a dozen of them, which you just are convinced are, pretty egregious examples of just what I call foul behavior, that you're not a good actor, that you're not the good parent, for acting in that way. This was a otherwise very, very routine request by a parent. You have to remember you might be the custodial parent, but that doesn't mean that your children don't have two parents with really equal custodial rights, and you really don't have a right to. I take the position you're hurting your children by doing that kind of thing. The kids probably wanted to go to the whatever it was that the father had suggested in that case, and again, as lawyers, you're developing your theory of the case and really presenting that through your questions and letting the court say that this is just a really unreasonable person. So unless you intervene, judge, and do something, chances are we're going to just face this situation forever for these kids, and courts don't want that. And in the judge's I have to say, in the judge's interests, that's a very, very difficult position for a judge to be in when you have two otherwise, halfway decent parents who just can't get along because there's so much animosity. I mean, they got a tough job. They definitely do.
Yeah, yeah. All right. Well, I mean, Jeff, this has been amazing so far. I don't know if there's any other suggestions you have.
Yeah,
If so, tell us, and if not, tell us how we can find you.
sure. Well, my office is here in Midtown Manhattan. You can find me. My email is jkaplan@kaplanlawny.com. And for anyone who has any questions or would like to talk about their situation, happy to do a consultation, and would welcome anyone reaching out or even emailing me with questions, things of that nature. But again, I think the most important thing is to really to find a lawyer who is, like you, like-minded, reasonable, and is going to really devote the time and attention to really knowing you and knowing your case and communicating with you, and isn't afraid to pick up the phone. We have a rule here at my office where, within 24 hours, every phone call gets returned to a client. No one
Wow.
is going to have a situation where they need a question answered and it's not going to be answered. You're going to get an email back or a phone call back, and the situation is going to get addressed or answered in a pretty timely fashion. If it's a weekend or late at night, it might not be till the following morning, but we're very accessible. You want a lawyer who's going to be accessible, especially a domestic relations lawyer.
Absolutely, because for a lot of our clients, they are carrying so much from the relationship with their ex, and often when a lawyer doesn't get back to them, not that it has to be immediate, but they take it as being given the silent treatment. And
Right.
it's basically repeating the same cycle of what they went through, and they get very upset about it. So I
Yeah.
think knowing there's attorneys that say, no, we'll get back to you like really quickly,
Yeah.
that's such a
Yeah.
comfort.
No, I find it's just, obviously it's better to get back to a client who needs a fast answer about something, but it's also a good way to establish a good relationship with your client right from the very, very beginning. That your lawyer is going to be responsive, and hopefully you're not abusing the situation. There are some clients who insist on using their lawyers as their mental health professionals, and we're not mental health professionals. I'm sure there are some lawyers who are, but you have to be careful because your lawyer is your legal professional and giving you legal opinions. and legal counseling. And, just because you want to talk to somebody, that's okay. But, again, at $600 an hour, you have to really make sure that, if you're just needing to speak to someone that, you consider that it's costing you a decent amount of money to do that, because lawyers are generally pretty busy people, and we just can't take an hour of every day to, talk to you about things that might otherwise be better addressed talking to a good friend or maybe a psychologist or someone like that. So you have to be mindful of that situation too.
Yeah, yeah. Well, thank you again, Jeff, so much. And one of these days, I am going to take the train to Grand Central when you're not at trial and walk across the street and meet you in person.
Looking forward to it. Again, all my pleasure. Thank you so much, Lisa, for having me. And it really is a great pleasure.
Same here. All right. Talk to you
Okay.
later. Bye.
Bye-bye.